Yes, let me fast forward something. Everyone wants to eat. You know, I make it happen.
Bulan. Okay, very.
Abali kwa muteni nga tali kweyatera okyuseeyo
nakyusizza yikanda ni wano
ate kino ekinene yono birabye akapa experience kati omuleka yakugamba experience
Extremely we are eagerly waiting. We are not High Court. Because of what I'm doing now, the whole of Takiza Besigye ne Haji Rutale. Akeetalo kukanjira tuli mu kulaba Dr. Kizza Besigye amaze okuba nti ayingirawo mu kkooti. From wherever you're watching us from, you're watching Extreme Media UB. And Extreme Media UB. Joliko era nga tuli kulaba akeetalo ko kayongedde kiraga Dr. Kizza Besigye amaze okuba nti naayingirawo naye gyesitanaba kuba nti no atuukira ddala muno munda nga boolaba akasabo boolaba aba kasita olaba abo aba prison nga bayingidde kitegeeza nti bamaze okuba nti no ate olwaleero osuubira nga heading bweri ng'omutwe we guli ogwa live eno kiki kyolowooza kiki kyolowooza olunaku olwaleero olowooza Dr. Kizza
Samuel Luizi Bindwa, Aaron Kiza, Kunihira Proskovia, Kato Tusime, Kakulu Tusime, Sullivan Uwe, Uwe, E-W-O-W-E, Mr. Farouk Kamria,
Yeah, my love.
Mr. Tukume Moses, Mr. Silas Uhuru, Uhuru, Mr. Sekab Yakubu Abubeka, Mr. Chief Michael, Mr. Bayan Nawe, Mr. Isaac Wagala, Mr. Julius Sekai. Respondent is represented by Mr. Richard Bilikumbuka, Chief of State. That is true, Your Worship.
Richard,
Bilikumbuka, Chief State Attorney. Worship, the matter was fixed for ruling. Receive, say.
well, the ruling is ready. And have instruction to pronounce the same. And the census number 1-2025, arising from Nakawa, application number 8 of 2025 at Nakawa, Human Report. First applicant, Kano, Dr. Kiza, Besigye. Two, Haj Obed Utale. Versus Uganda. Before Honorable Lady Justice Content Company Anya, ruling. The ruling is of 17 pages. Lady Council, you want each and every word written on this ruling, or you want silent features? And for the one who has not yet, who did not get the chance of getting to yet is interested, we shall pronounce the whole of it, I think, for the benefit of the public. Background. Kano retired Dr. Kiza Besigye and Haj Obed Utale, hereafter referred to as the first applicant and second applicant, and where the context permits, the applicants were charged with 1. Prison contract section 223, subsection 1, part C of the Penal Code Act, Cap 128. 2. Misprision of prison contract section 25 of the Penal Code Act, Cap 128. The prosecution alleges that the applicants and others who attended between the year and November 2024 while in various cities, including Geneva, Switzerland, Athens, Greece, Nairobi, Kenya, and Kampala, Uganda, contrived, employed, or matter by force, of Arms to overturn the government of Uganda as by law established and expressed or declared such law, act or matter by utterances and overt acts. In the alternative, the prosecution alleged that the applicants and others to at large in the places and in the time frame affirmation, knowing that another person intended to commit treason, did not report the same to the authorities or use all reasonable endeavors to prevent the commission of treason. Legal basis of this application. The applicant brought this application by notice of motion under Article 23 or 6 of the Constitution of the Republic of Uganda, 1995, Section 15 and 16 of the Trial on Indictment Act 25 and Rule 2 of the Educator Criminal Procedure Application Rules for orders that A, the applicant be admitted to bail and released from remand / custody. The grounds of this application stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that on the first day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrate Court of Nakawa at Nakawa and remanded in custody. The offences with which the applicants are charged are only bailed by this honorable court. C, the applicants are responsible citizens of Uganda who have permanent places of abode as follows. First, applicant at Wiyinja LC1, Wampewa, Katanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukongiri Municipality, in Rukongiri District. Second applicant at Kisibula Village Cell, Mutundo Ward, Gongola Samagabo, Makinde Wakiso District, for the second applicant. The applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for mention or trial as and when once released on bail. The assistance of the applicants demonstrate this respect for the law and for any bail processes they have benefited from. The applicants have not been committed to High Court for trial and are willing to comply with all reasonable conditions set for their admittance to bail. G, the applicants are of advanced age and have substantial sureties who are willing to ensure compliance with bail conditions once applicants are released on bail. H, it is fair and just that the applicants be admitted to bail and released accordingly. At the hearing, the applicants were jointly represented by Honorable Elias Lukaku, Mr. Ernest Kalibala, Mr. Apollo Katumba, Mr. Wanda Samuel, Mr. Samuel Moyezi, Mr. Podhira Proskovia, MS Podhira Proskovia, Mr. Kato Musimi, Mr. Bayan Rinawe, Mr. Farouk Kamlegea, Mr. Kintu Michael, Mr. Amanya Kofi, Mr. Kato Wilson, and MS/Oguru. The respondent was represented by Chief State Attorney Joseph Chomohendo and Chief State Attorney Richard Bilivumbuka. Both the applicants and respondents made oral submissions at the hearing and filed written submissions for which this court is grateful. The said submissions have been considered where necessary. Submission. It was submitted for the first and second applicants as follows. Article 23, 6A of the Constitution of the Republic of Uganda as amended spells out the right of an accused person to apply for bail and enable this court to grant bail on such conditions as it considers reasonable. Section 15 of the TRA, Cap 25, provides that this honorary court may at any stage of the proceedings release the accused person on bail. Pursuant to Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Motion Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel for further cited the case of Foundation for Human Rights Initiative versus Attorney General, motion petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. One of the exceptional circumstances that listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16th November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Besigye versus Uganda, application number 8 of 2011, counsel said that the courts have recognized that prison conditions are not favorable to the health of old people, who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides that other factors that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants said that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious, grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. That in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24, 2024, the International Crimes Division of the High Court, ICD, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application, and held that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provide that doing so does not compromise the interest of justice. It was further submitted for the applicants that the nature of the offences with which the applicants are charged are political offences and that these two are not. And on that account alone, the kind of offences in respect of which bail cannot be granted, that the first applicant particularly has been charged with various political offences over the years, offences in respect of which no provision has been returned by the respondent. Council cited Makoha Samuel and 35 others versus Uganda Supra. Council submitted that other conditions to be proved before court include antecedents of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panju versus R 1973 Suffolk reports at page 282, where the court held that allegations of interference with witnesses must be substantiated and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in the application for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. In reply, counsel for the respondent submitted as follows. Section 15 of the Child A and Guideline 3 of the bail provides conditions that court should take into account in its considering bail applications, including the substantiality of sureties, nature of the offences, age of the applicant, possibility of interfering with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Guideline 15 of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties. The age, work, business of the sureties, character and antecedents of the sureties, relationship of the surety to the accused, both applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties. To wait, Honorable Semuju Nanda, a close friend, age 52 years. Honorable Francis Mwenjuche, a close friend, age 41 years. Honorable Mokindo Heron, Tony, a close friend, age 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, age 50 years. And the second applicant, produced by Nakita Karima. The second applicant produced Nakita Karima Mutare, a wife and age 58 years. Nafuka Zukura, a daughter age 27 years. And Kanso Kambo Hamza, a friend aged 48 years. Council submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And that such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. I also cited the case of Mogera John versus Uganda, criminal responsibility number 21 of 2025 at International Crimes Division. Honorable Lady Justice Alice Komhani Kauka held. It is my constant view that a surety should possess a certain amount of authority and or influence over the applicant. The sureties presented by the first applicant have no authority and or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from IOC 1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, counsel submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. The first applicant produced only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Counsel added that friends do not have the necessary leverage or influence to ensure the first applicant's compliance, and are most likely unwilling to take steps to enforce compliance. Counsel cited the case of Besigye David versus Uganda Criminal Section number 9 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Counsel said that if court was uncomfortable with raising the applicant based on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to leave the first applicant with just friends as sureties. In his submissions, counsel submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicant dispense this requirement. Counsel cited the case of Mugera John versus Uganda Business Application number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Alibiza upheld the above view. It was further submitted that none of the sureties provide their work of business identity cards. What was annexed
and the chairman of Electoral Commission, Mr. Speaker, made a request to me that when opportunity
business of employment or gainful income and disposable income, which are critical in assessing their substantiality. In a single Anna versus Uganda criminal submission number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability of by the sureties, regardless of their position in society or government, is fatal and goes the core in the grant of bail applications. Advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved, as was held in the case of Besigye David versus Uganda criminal application number 29 of 2019. The offences with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Colonel retired Dr. Kiza Besigye, Constitutional Reference number 20 of 2005, the Justice of the Constitutional Code held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offenses. The court must weigh the gravity of the offense and all other factors of the case against the likelihood of the applicant absconding. In the case of Foundation for Human Rights Initiative versus Attorney General, Supreme Court Constitutional Appeal number 3 of 2009,